You're very ready. Okay, here we go.
Hello, tunasema mambo ya digitization.
Very well with technology, and this we want to thank all the stakeholders, the advocates, and even litigants, because they have also embraced technology as an enabler to access to justice. This is the future, as everybody admits. Technology is the way to go. We are now doing e-filing. You don't have to travel to court to file a matter. You can file it digitally. And we are also having virtual courts whereby you can conduct your proceedings from your device, wherever you are. We just give you a link, and you can link to the court and make your submissions. Mostly in applications, we do virtual hearings. Also in matters, many parties prefer to hear, to prosecute their matters virtually. So we have in Nairobi completely completed e-filing, and we are moving to the next phase of ensuring that we embrace virtual courts, and we can actually become paperless courts. You can file, and we can conduct the entire hearing without resorting to the paper documents. We will be moving to Kisumu also with to launch the e-filing, and it's also being prepared for the entire country in the 47 counties to move with e-filing and embracing technology as an enabler to justice. That way we do not have missing files, complaints of missing files. Everything is in the system, the CTS system. The court filing fees is all assessed, and it can be tracked. No loss of funds, fines, and all that, it's all in the CTS system. Doing very well with the alternative justice system. It is what we are calling under the STAJ, the vision of the judiciary. We are calling it multi-door approach to justice. Social transformation through access to justice, the vision of the judiciary as a pillar on alternative justice system, as an alternative justice system, including arbitration, court-annexed mediation, and this way we reach more people, because it's only 10% of our population who are able to access formal justice system. Majority of people go to alternative systems through the chiefs, through the churches and mosques, or in the villages through the elders. So we are trying to formalize that, so that if you have had your matter arbitrated through the alternative justice system forum, which we have created, then we can adopt that ruling. We've already rolled it out in Kajiado, Isiolo, and Nakuru. And we are moving also in the other stations, attaching it to the court-annexed mediation and getting those mediation suites, both for the court-annexed mediation and for the alternative justice system. When we were opening the small claims court in Meru, we had a session with the Nanyuki, because they are also trying to customize Nanyuki to be adaptive to the principles of the Constitution, so that they can also be a forum of NJS of the disputes in their region. And we are moving in all regions, encouraging communities to set up alternative justice systems to resolve issues within the communities. One, it is to identify the backlog of cases, identify the number of magistrates that we have in a station, and sharing out those cases, and the court stations themselves agreeing what time frames do we give ourselves to complete these cases. And I believe when we convene next year, we will be telling a success story of how we can be real time. We are looking forward to how Kenyans can be able to file their cases, and immediately we give them a date for hearing, and within 3-4 months we finalize their case, and within 1 year we have finished their case. Because no Kenyan wants to come to court year in, year out for their cases. But we seek cooperation from Kenyans because we have identified some of the bottlenecks. The reasons why there is backlog is because they file cases and they don't want to prosecute them. In fact, the land and environment judge here in Nakuru, Nanyuki, tells me that sometimes she fixes matters in court, she sits in court, and parties do not appear. What do you do as a judge or a magistrate? You can't just dismiss a matter. You want to know why they have not come to court. So you move back to the chamber to write to them a letter to come for mention to tell you why they are not prosecuting the case. Then also, our colleagues, the advocates, they seek adjournment for their own known reasons. They don't want to proceed with the matters. They adjourn the matters. Also, other parties file cases not for purposes of prosecuting, but for purposes of teaching a lesson to the other side. So they don't want to proceed with it, but they want to say, I took you to court. I have sued you in court. And then there are others who are defendants also, who will use every means not to have the case moved because they do not want to discharge the responsibility that is being asked of them.